I don't know, it's foreclosure. Foreclosure. Yeah.
Thank you all for joining, ladies and gentlemen. We're just going to get started in a few minutes.
Good evening, everyone. Good evening, and welcome to the Medgar Evers Du Bois Bunch Center's Legal Arm Foreclosure Program. I'd like to welcome everyone and our co-sponsors and our presenters. We have an evening of a wealth of information, so we want to just get started. Why are we here? Because foreclosures are a serious issue that many homeowners are facing in New York City. The Du Bois Bunch Center prides ourselves on doing the data and the research, so we know why problems exist, and also arming residents of New York City with the information that is needed to tackle some of these problems. So I want to introduce our co-sponsors. Our co-sponsors are the Neighborhood Housing Services of Brooklyn. Angella Davidson will be speaking on behalf of NHS Brooklyn. On behalf of NHS Jamaica, we have Lori Miller. And we have Janay Malloy of the National Association for Real Estate Brokers. We also have two additional presenters, two attorneys, Crystal Burden, and we have Jjais Forde. So we have an evening of a wealth of information to arm everyone with anyone's foreclosure problem. The format of today's program would be, we have the 5 presenters, and then we're going to have the question and answers. If anyone has questions, you could just put those questions in the chat, and myself and the co-moderator, Dr. Frank Hurley, will pose those questions to the presenters. And then after the program, all registrants will actually qualify to speak to an attorney on a hands-on one-on-one counseling, and we'll address your specific foreclosure issue at the Du Bois Bunch Center. So without further ado, I would like to introduce the co-moderator, Dr. Frank Hurley, who is with the Du Bois Bunch Center's legal arm.
Good evening, everyone. My name is Richard Hurley, Dr. Hurley, and I have the pleasure of introducing our dean. Dr. Zalima Blair is currently the dean of the School of Business at Medgar Evers College. She serves as the executive director of the Du Bois Bunch Center for Public Policy. She's a former professor and also the former chairperson of the nationally ranked Department of Public Administration. She's the only one in our department with a doctorate degree and a JD degree. So I always listen to her. And so we have the pleasure at this time to do just that. Dean Blair, would you please?
Great. Thank you, Richard, Professor Hurley, Attorney Dudley. And thank you to all the sponsors and everyone who showed up here tonight. Again, my name is Emma Blair, Dean of the School of Business. And I just want to say that tonight's workshop event is not just about forms or the law or, of course, you're gonna be encumbered with law, but it's also about, or mostly about people. Losing a home is not just losing property, it's about losing stability, generational wealth. We know the numbers there. It's about losing population in our communities. It's about losing, political power, economic power, social power. So it's about all of those things. And so I want you to, really tap into the resources that are here tonight. If you know someone, text them and tell them to join. You are in great hands with these attorneys, I promise you. And they're very inspiring. And come by the center, come to our office hours, and tell the community to come, because we want to keep this as our community. So thank you, and I'm going to sit back and enjoy the program.
Thank you, Dr. Blair. Okay, so tonight we're going to focus on mortgage foreclosures. The overview of foreclosures: you have many types of foreclosures. You have mortgage foreclosures. At some point, someone sat down, they signed a note, they signed a mortgage, they promised to pay money back to a bank. At that closing, they also signed a contract where they're permitting the bank to put a lien on their house until they finish paying off the money to the bank that you borrowed. If you don't pay that lien on that house, then the bank will exercise their rights under the contract that you signed and try to sell your property so they could pay themselves back. So that's a mortgage foreclosure. We also have tax lien foreclosures. Tax lien foreclosures, you fall behind on your property taxes, you fall behind on your water. You can also fall behind on certain agency liens that will transfer that to the tax departments. And then the city of New York will then foreclose on your property so you can pay themselves back. We also have a condo. We also have a condo foreclosure when you don't pay your HOA dues, and they exercise their rights under the lien that you signed with them, and then they'll sell your condo and pay themselves back. And we also have the co-op foreclosures, which are in a total different category, and we're not discussing that at all today. So the only foreclosure we're discussing today will be the mortgage foreclosure. You could take pieces of that and kind of apply it somewhat to your condo and tax lien foreclosure, but we are focusing only today on the mortgage foreclosure. So I would turn this part of the program over to Dr. Hurley, who will present our first speaker for the night. Dr. Hurley.
Once again, my pleasure to introduce this next speaker, Angella Davidson. She is a HUD certified housing counselor and works for the Neighborhood Housing Service of Brooklyn, CDC, Inc., a HUD certified housing counselor agency. Angela spent over 15 years working in financial industries on Wall Street. Angela joined the NHS in 2008 and is currently the program director working in various areas, including foreclosure, prevention and intervention, loss mitigation, financial counseling, and coaching and reverse mortgage counseling. She is committed to assisting her clients to preserve wealth through preservation of home ownership. Angella holds degrees from Bernard M. Baruch College and is certified in a whole host of areas. Without further ado, would you please, Miss Angella Davidson?
Good evening, everyone. Thank you, Dr. Hurley, for that great introduction. And thank you for having me on this panel tonight. So I'll just gonna talk about foreclosure from the aspects of housing counseling and what we do at NHS Brooklyn. As was said, NHS Brooklyn is a HUD certified agency, have been around for over 43 years with our mission to preserve and to help homeowners to buy and to preserve homes and to stabilize families and communities. And so tonight I am just going to touch briefly on what we do at NHS Brooklyn as it pertains to foreclosure. So we work with homeowners experiencing hardship or already currently behind on their mortgage payments. We also work with homeowners who are actually in foreclosure, meaning they have been served with a summons and complaint. And I know Attorney Burden will talk about that later on. We also work with homeowners who are experiencing hardship. They might not be behind, but they are facing imminent default for foreclosure. So what is it that we do at NHS Brooklyn? We start our process off through an intake where we get homeowners to do an application, submit certain documents that we work with to figure out their situation. That is followed up by a one-on-one counseling where we sit with the homeowner, we review the homeowner's financial situation and their mortgage situation. What do I mean by their mortgage information? We seek to find out if this homeowner had prior modifications in the past or are currently in an loss mitigation application. As we know, one of the ways that these servicers deny or investors deny homeowners for workout options is to say that they have had maybe 4 modifications before, so they're no longer eligible for another one, or they might have had a loss mitigation application within the last year, so they will not be reviewed for another one. So we sit with them to figure out where they are. We help them to create an emergency budget. So we know people who are facing default, who might be facing other hardships. We have to look at budget, right? So we think about what are some of the things that we can eliminate from your current budget. And we'll put that back later on once we get ourselves stabilized and get our housing situation back on track. So we help to create that emergency budget. We help homeowners to identify who the investor on the loan is and the type of mortgage loans that they have. We do know that the person who sends us our mortgage statement every month is not the investor on our loan, right? They are who we call servicers. They are employed by the investors who pay them to manage their mortgages or mortgage loans. And so they send out those documents, but they're guided by the guidelines of those investors. And some of those, we help them to identify the type of mortgage loan that they have. Some of those type of mortgage loans are FHA loans, Fannie Mae, Freddie Mac, VA loan, USDA, portfolio loans, and private loans held by the investors. By doing so, we are able to help the homeowner to evaluate for what loss mitigation options are available to them. And such options including retention options. All right. And then the first thing that we look at with this person is to see financially where they are. Are they in a position to reinstate that loan? Right? And we can reinstate that loan through various options. If you have savings, we can use that savings to bring the loan current. You can tap into your 401k. We don't always advise that, but if it's a way to stabilize your family, then definitely tap into that. And then oftentimes we administer grants that are out there that are available to these homeowners. And they might not know because they're not working with an organization, like an NHS. Most time private attorneys are not people who can tap into those private resources to help clients get back on track. So we help them through that option as well. And one other thing is for people who are mature, a reverse mortgage might be an option to keep them keep that house from going into foreclosure or being sold at auction. And then we have the one-shot deal through the Human Resource Administration, commonly called HRA. And so we help them to apply for those one-shot deals, which they can use to bring their mortgages current. Or that can be a twofold option where we're using that one-shot deal to assist with getting a loan modification as well. So if you can bring a part of the loan current, oftentimes the investors will allow for partial payment along with a modification. And then we think of what are some retention options that are available. And I'll just talk about a few that are FHA specific. FHA have what is called the informal and formal forbearance plans. So if you're in an FHA loan, you can get an informal forbearance 3 months. That is just a verbal forbearance. And then if a longer one, maybe 6 to 12 months, it's called the formal forbearance plan. And that has to be in writing, where you would get the application sent, the document sent to you, and then you would sign that and send that back. And then there's also the special forbearance, and this is for people who are unemployed. So if you have an FHA loan, it's not the end of the world, right? That you're not working, because there is that special forbearance to help to keep you out of foreclosure. While you're in that plan, there is no foreclosure action taking place. And then also we have the standalone loan modifications that are FHA backed. And then we have partial claims for FHA loans, and the partial claim is used to pay down the arrears that you're owing, or to pay down 30% of the balance of your loan to help to bring you current. That's a standalone new mortgage loan that gets recorded as a lien on your property. And then we have a standalone partial claim or partial claim with modification. And then there's a new one called the payment supplement agreement, where any FHA will refinance your loan into a 5-year loan, right? It's only good for 5 years. They'll reduce your payments to 3.5%. They will use partial claim to help you with that. But that once that 5-year comes, you go back to your regular mortgage payment. And then we have the non-FHA retention options, such as the regular modification that everyone talks about. I would like to get a modification, and it's maybe one of the most common ways to help someone facing foreclosure to get out of foreclosure. And we also have the flex modification, which is a modification used by Fannie and Freddie. And then we have regular forbearance that has nothing to do with FHA, where you can get a forbearance if your investor allows, where you get a pause on making monthly payments on your mortgage. And, that is something that will be negotiated between two sides. And you'll know if it's for 12 months, if it's for 5 months, and you'll get that documentation. You will sign that and send that back. The important thing to understand, though, about forbearance agreements, that it's just a pause. That money is still owed. Right. And so we have to figure out, once that forbearance period is over, how do we get back on track with that? So it's important to work with a housing counselor or an attorney to guide you through that process. And then we also have the deferment. For someone who's behind, those arrears can be put to the back of the loan. It can be capitalized back into the loan, or it can become another standalone mortgage lien on the property. And then you have the option for bankruptcy, and I'll only mention that. And that is done with a plan, and you need to be evaluated by an attorney. Then the last thing we do, we help homeowners prepare and submit their loss mitigation application package to their servicer once it's determined that loss mitigation is an option for that homeowner to pursue. And then there are times when you might need to submit a complaint, right? You have been trying and they haven't been working with you. So there might be the need for a complaint, and the CFPB has been gutted. So I won't even mention CFPB tonight, but to the bank's ombudsman office, we oftentimes do that. And then to the Department of Financial Services, who governs some of the lenders who work, banks that give loans in New York City and state. And then, right, so then I'll just talk about briefly if there's a sale date on the property. And I did mention bankruptcy before. One way of stopping that foreclosure is through bankruptcy. Again, under the advice of an attorney. Also, there is another option. If you have more than 37 days before your actual sale date, you can use a loss mitigation application to prevent any further foreclosure action while your loan is again being evaluated for some workout option, whether it's a modification, a repayment plan, whatever they deem that you need, that is available to you. And then also one other thing, and again, under the advisement of an attorney, you can file a document called an order to show cause. And I know the attorneys on here will talk about that. We have partner attorneys who we call friends of the courts, and they will help you to put in that order to show cause free of cost. I know everyone doesn't want a free attorney, and I know we have wonderful attorneys on the call here, on the presentation here tonight that, someone can reach out to if they need that assistance. And then for non-retention options, you have the option if you're someone in foreclosure and you don't think you're able to keep the property, you have the option to sell your home through a regular sale, or the bank might approve you for consideration for a short sale, and you would work with again, you can work with a housing counselor and attorneys and real estate agents to take care of that short sale. And then you can also be evaluated for a deed in lieu of foreclosure. And so that is my presentation for tonight around what NHS does to help people with facing foreclosure. Thank you.
Thank you so much, Ms. Davidson. You're always a wealth of information. I took notes myself, so I can kind of add that to how I counsel clients and send people directly to NHS Brooklyn for all the Brooklyn residents. So thank you for that wealth of information, letting us know there is money out there, there are grants out there, there is help out there, which is why we're here tonight, to make sure that people don't stop, raise their hands in frustration, to make sure that they can do something before their house is actually auctioned. There are so many opportunities for a person to do something. I'm bringing our next speaker. Our next speaker will be an attorney, Crystal Burden. She's a real estate attorney, a real estate litigator. She handles real estate transactions, litigation, foreclosures, and bankruptcies. She has been admitted in New York State for the past 33 years now. And I welcome Crystal Burden as presenting an overview of the court foreclosure process.
Believe you're muted.
Okay, can you hear me now?
Yes, thank you.
Okay, great. I wanted to thank Attorney Dudley for all of those kind words, and Ms. Davidson is a hard act to follow, for sure. So I'm going to just let you know that whatever years of experience I have behind you, Ms. Davidson makes up for that in just pure information solely. So what I'm going to be doing this evening is giving you but a glimpse at what you can expect, unfortunately, through the court system. In New York, there are other options to go through foreclosure other than judicial, but in New York State, you must, and it is a requirement that you go through a judicial process, meaning that the court is the final say on whether a foreclosure is issued or not issued. So that's something that you should know. Just as a background portion of this, before the case gets into a foreclosure, meaning as I mentioned, this is a judicial state, so you have to file a summons and complaint. before you get to that point, or before the bank gets to that point, there has to be a 90-day notice that is served upon you to, I know that Ms. Davidson probably wanted to discuss that in her presentation. So briefly, the 90-day notice has to be served upon you before a lawsuit can be brought. The 90-day notice has to give you various options and tell you about some of the things that Ms. Davidson spoke to you about. Not all of the things. Ms. Davidson has a lot of tricks in that bag, as well does, I believe, Miss Miller, if I'm not mistaken, from Queens. Yes, Miss Miller. So those two ladies, those are the people you want to know. Those are the money people. Those are the people that have all the tricks and all the bag of things that can fix this. I unfortunately just have, the process, but you want to know those two ladies. So at the end of the day, in that 90-day notice, that notice has particular requisites that are required. The notice has to be in a language that you speak. It can be in English, but it also has to be sent to you in your native tongue if the bank knows about it. So if the bank knew you spoke Spanish and Spanish was your first native language when they gave you the mortgage, they need to send that notice to you in Spanish. It cannot only be in English. It has to be translated for you. You must understand it. But I'm not going to really get into that so much. I was given specific guidelines. I'm to talk to you about the les pendants to the auction date. So that's what I'm going to do. So the initiating document that the bank will file even prior to filing the summons and complaint is something called the les pendants. That is a particular lien document that is filed against real property, period. It's only used in real property matters. And that les pendants has specific verbiage about what it's attaching. And it has the right to file this document against your property, a lien against your property. Again, this is not foreclosure. It's just a notification to the world that this property is in distress. This property is going to be utilized to satisfy a judgment from a lawsuit that has also been filed in that courthouse in tandem with this lien. It's two separate processes, two separate documents, two separate things. So once that actually it can be done simultaneously, but again, that's what the les pendants does. Although the les pendants has been filed on your property, it doesn't preclude you from proceeding to sell that property if you can before the foreclosure date. Like I said, it's merely a notice to the world that your property is the subject of a foreclosure proceeding. And that's what it does. So the foreclosure proceeding itself is commenced by the filing of a summons and complaint. The summons is a jurisdictional document that needs to be served upon you in order for the court to have jurisdiction over you and in the foreclosure proceeding. The complaint itself tells the story to the court as to why this financial institution believes that this property should be foreclosed upon. It contains things like your name, the property address, and the specific description of your property. Every property is considered to be unique in nature, and it's pretty much identified by boundaries and directionals, and also a block, a lot, and a section number. So this document, this complaint will identify the property, a specific property that is the subject of this foreclosure proceeding. Once you receive that summons and complaint, which has to be served on you either personally or by something called nail and mail, or a fix and mail. Typically, the banks use, at least in my experience, a fix and mail versus personal. Depends. If they can get you, they can get you. If they can't get you, that they're gonna affix a copy of this lawsuit to the door of the property, and then they're gonna mail a copy of the same document to the property. And if they do those two things, they have satisfied the jurisdictional requirements of the county in which the property is situated. So the lawsuit that is brought against you will be typically in the county in which the property is located. It should be, and it usually is, unless something else is going on. Typically, nothing else is going on, so that's where your lawsuit will be. So that's where you would respond to. Once you get the summons and complaint, if it's served on you personally, you have 20 days to respond. If it's served on you by nail and bail or fix and mail, then you have 30 days to respond. So that's the thing. And your response has to be in writing. So it has to be, it doesn't have to be formal. You can do it yourself. There are attorneys that are at the courthouse that can walk you through that for free downstairs in the bowels of the courthouse. Typically in Brooklyn, it's in the lower level of the courthouse. I'm not sure where it is in Queens, but I believe it may also be on the first floor, if I'm not mistaken. But there are legal services available to you if you feel like you can't afford it or whatever the case may be. As Ms. Davidson said, you don't have to hire an attorney initially if you think, it's something beyond you. Typically, it's better to get legal advice that you trust early on to set the stage of how things will go. It's probably not better for you to answer it yourself, but if you're running up against a deadline or you're afraid of something happening, it's better to get in there, get a response, than allowing yourself to default on it. They're not playing around. The lenders and their attorneys are very serious if they've gotten to this point where they've prepared a summons and complaint. They smell blood, they're in the water, they're sharks, they're looking for their money back. And they're not in the business of being touchy and feely about this. It is not personal, it is business. They could care less. They don't care about your nieces and nephews or your brothers and sisters and all of the things that are tied up into this property. What they do care about is how much you owe, accelerating that debt, getting a lump sum payment, and moving on to the next. So you need to file an answer. If you don't file an answer, all is not lost, because once they serve that summons and complaint on you, just as I said, they're sharks in the water, they smell blood. They have something called a mandatory settlement conference that must be held in these cases. They are the ones, meaning the bank is the one that triggers the date upon which this is happening. So whether you answer them or don't answer them, they're going forward with this case. They're signifying to the court that everything that is expected of them from this point, it has been done. They don't know what you're doing. You haven't paid them. They haven't heard from you. You're not responding to them. They just want their money. And they're like, Judge, can we have our money? Give us a conference date. They're not going to show up, or whatever the case may be. We want our money. So the conference date is set. You have to be noticed on that as well. You will definitely get a notice. If you get a notice and you're aware of it, go to the conference date, even if you have not filed an answer. You may feel like, oh my God, I haven't responded. I've been hiding under my bed. I've been putting my head in the sand. I've been pretending like this hasn't happened. I haven't gone to see Miss Davidson. I haven't gone to see Miss Miller. I haven't reached out to my community to let them know what's happening with me. So all is lost, and I can't show up empty-handed with just me in my pockets. You are wrong. Go to the courthouse, show up, and just be invested. Let them know Yes, I missed that date. Yes, I should have filed that answer. However, it didn't happen for whatever reason. You have a redo, you have a reset, okay? So when you go to that conference, you can now talk turkey with these attorneys whose job it is really for the bank to get the best possible outcome that they can get, okay? The reality of the situation is you signed a loan document. This loan document, the reason why they allow or they lent you money to get this house in the first place is because they were going to make money. If you looked at your mortgage document and that the I can't even say it, the amortization tables, it tells you exactly how much money this bank and financial institution is going to make on you during the life of this loan. Trust me, it's a lot of money. They want that money. They would much prefer to allow you to stay indebted to them than to allow you off the hook, okay? So that's the reality. So they're not doing this out of the goodness of their heart. They really want to make money off of you. And how they do that is they allow you to stay in the loan and they collect their money monthly, and most of it being paid to interest monthly, very little paid to principal early on. And they want that. They want to keep you. They want to do business with you. They thought you were well enough to do business in the first place in order to undertake the loan, because this property is in a location and in a place that was okay, that they felt they could actually sell eventually if anything should happen and they could get their money. They felt you were in a good enough situation when they lent you the money and that you were qualified. Trust me, if you were not qualified to get this money, they wouldn't have given it to you. So they're willing to work with you. They want to do business with you. Sit down at the table, try to do a workout, talk to Miss Davidson, talk to Miss Miller, go to them, employ the use of the services that are readily available to you. In addition to Miss Davidson and Miss Miller, there are services available through the Attorney General of New York State. I think it's called HOPP, HOPP, okay? So they have numbers, hotlines that are available through the Attorney General's office. Reach out to them. There's counseling services everywhere. And the loss mitigation letter that you received when you defaulted way back when, before the institution of the litigation, it sets forth at least 5 different counseling agencies to provide you the resources that you need to save your home. This is something that is an asset, that's an appreciable asset. You want to protect your investment. You have equity built up in this home because you have been making payments thus far. You want to protect that investment, protect those payments that you were making that were so hard fought, that you basically made the decision that you wanted to direct your dollars in this way rather than buy that new car, or rather than buy that leather coat, or buy this whatever. You made that decision early on. Stick with it. It was a good decision. Real property is a good decision to invest in. So stick with it. Like I said, the bank will at that point be at the conference. They'll be looking to talk with you. They'll be looking to either do a loan modification or do a situation where you're actually agreeing to repay the arrears of payments that are due. They will offer you possibly something. They may even offer you a refinance. Deed in lieu, that's an acceptable circumstance. I'm sure someone will talk to you later on about that, but very quickly, you give them the deed and you walk away from the property. You have no default judgments. You have nothing. They take the deed. That's it. You're free. You can walk away from the property, but you also walk away from the equity that you have built up in the house itself. And if it's significant, you want to keep that. That you want that equity, you want your money back. So maybe you don't want to do a deed in lieu, Maybe you want to do a workout with them, and you would go to Miss Miller or Miss Davidson because they're the money people, and they're going to put you in the right direction and in the a better program for you so that you don't default in the future. And they're going to talk to you about private mortgage insurance and in ways in which you can bring your payment down. If you had met that threshold where you didn't put 20% down and that was part of your payment, they're going to knock that out of the way for you if you have now 20% and no one has ever bothered to take that off your back. So that will be a monkey off your back, and it's a good thing. Okay, so at this table, like I said, settlement will be offered to you. I hope that you do settle. But if you don't settle, what will happen is you've defaulted and you haven't filed an answer, you'll be given an opportunity to file an answer you won't see a judge, you'll see something called the law secretary. They'll give you that time to file your answer. At the same time, they'll give the plaintiff, which is the bank, an opportunity to enter into discovery. Quite frankly, as I said to you, they're sharks in the water. They don't want to wait around and mess around with you to do, document exchanges and all of this and do some sort of an accounting, whether you've made your payments and whether you were properly credited and whether they credited the right amounts to principal versus interest and all of it. They don't want to do that. So what they will do is do something called accelerated motion practice. And what that looks like is either one or two types of motions. If you have you have filed your answer and you're going into litigation, or you haven't filed your answer, but you're still going into litigation because the court has given you an opportunity to file your answer, they'll file something called a summary judgment motion against you. That's an accelerated motion. And what that summary judgment motion says is, Your Honor, this person hasn't made the payments, hasn't lived up to the agreement and the loan requirements, and pursuant to the mortgage document that they signed at the same time that they signed the loan, we're entitled to this should they default. And as a result of that, Your Honor, we want an accelerated judgment of foreclosure and an order of reference appointing a referee to oversee the sale of this property. The referee's job is to go through the documents and ensure that the monies that they're asking for are all accounted for properly, and that you're not being taxed for things that you shouldn't be. But I will say this to you, that in a foreclosure proceeding, there are times when the bank has to incur certain costs that you haven't calculated in for loss mitigation, and that is preservation of the property. So they'll go in and they'll board it up, or they'll pay, certain bills on the property just to keep it together so that when they get their hands on it, it's available to be sold at the highest price, period. Okay, so that's called the property preservation aspect of it. Okay, so either they're filing a summary judgment motion and trying to get that accelerated judgment of foreclosure and order of reference, or you've been given that opportunity, as I mentioned at the conference, to file that answer. And that answer hasn't been received. So now they're filing a default judgment against you and an order of reference. So now again, they're saying you owe this money. You haven't stepped up to the plate. You haven't filed an answer. Your Honor, we don't know what they're doing, but we're entitled to our money, and this is why, and blah, blah, blah. Well, they have a referee that has been appointed, and I have served in that role for many a judge. And, it's our job to sit down and compute what is or isn't due to the bank at that point and go through the mortgage document and the loan document to ensure that the interest that they say they were going to charge was correct and your monthly payments were correct and all the things. So again, The default judgment and order of reference is being presented to the judge. Again, it's an accelerated way of handling and resolving the issue with the bank, none of which are in your favor, none of which are for you. Sharks in the water. These are shark moves, right? So either they're gonna get the summary judgment or they're gonna get the default judgment. Once they get those judgments, then they'll have to file something known as a motion to confirm. And that motion to confirm is a motion to confirm the referee's report of what is owed and due. Okay, so once that is signed and issued by the judge, then it goes to a judgment of sale. Okay, you get your judgment of sale and judgment of foreclosure and sale after the motion to confirm that report and turn it into a final judgment of sale, a judgment of foreclosure and sale. Now it's signed. So the next thing would be, excuse me, I'm just going to turn my page here. There will be a notice of sale that that comes out of that judgment of sale. Okay, so there will be that referee that I talked about that's responsible for calculating how much you owe, how much the bank is saying you owed, pursuant to the documents that you signed at the closing that you really didn't have a chance to go through. Your eyes were blurry. There was like 1,600 pages of documents. Nobody could possibly expect you to go through and read and comprehend any of that crap. And you don't even know until now you're sitting there, you're like, I signed what? What's happening? What did I give away? And really, at the end of the day, this is all for the benefit of owning in the United States. This is how it's done. Okay, so at the end of the day, you'll get something called a notice of sale. Okay, the notice of sale has to be issued within 21 days of that judgment of sale, judgment of foreclosure and sale having been issued and finalized. Okay, so essentially at least. And it may be several weeks that notice runs in the paper advising the public that your home is now going to be sold on a particular date at the courthouse steps. It used to be that the house would be sold at the quote unquote courthouse steps. Literally, I have offered property to be sold on the back steps of 360 Adams Street. Literally. And that was like, I would say 25 years ago. Now we're a little more civil, right? So we're a little more civil with it. So what we do is we don't go to the courthouse steps anymore. We go to a room like the jury room at Kings County, and it's filled with all of these people who are sharks and who are looking to get your property for $1. It may be worth $500,000, but they're looking to get it for $1. The good news is that the judgment of foreclosure and sale has an upset price to it, typically for the bank, right? So the bank needs to get a certain amount of money. The bad news is that if that's all they're after, sometimes that can eat away whatever equity you have, and it puts you into a situation where you're either coming out ahead or coming out behind. And somebody else will discuss all of that with you. So at the end of the day, if I had to say one thing to take away from, you know, my talk with you this evening, don't let yourself get there. Talk to Miss Miller, talk to Miss Davidson, work it out with them. They have the resources. Don't miss the meetings. Give them the documents they ask for, work with them, comply to them. Because if you don't comply to them, you're going to have to deal with the bank's attorneys, which I can guarantee you, they are, when I tell you heartless, and they are not yielding at all. So they're more demanding than Miss Davidson and Miss Miller will get. And Miss Miller and Miss Davidson have your best interests at heart. They do this because they really want to help you. They do this because they have an interest in the community. They do this because they want to see you stay in your house. They care about your kids and generational wealth and things passing from one to another. So anyway, that's the end of my presentation. I just want to thank the Du Bois Bunch Center for inviting me here to speak to you today. I really appreciated it. I enjoyed the experience, and I just really am so thankful that I've met all of you. And you know, I just turn you back over to Mr. Hurley and Miss Dudley, and I wish you the very best, and may you never come in my office looking for help.
Thank you so much, Crystal. Thank you so much, Crystal Burden, for that information. Crystal has helped hundreds, if not thousands, of residents in New York City with their foreclosures. So I'm really proud to have her here today. And thank you for that wealth of information. I know you could have just, when we get together, we just continue to talk about this stress situation. And we talk for hours and hours and hours. So thank you for showing up and offering your assistance.
My 2 cents.
Your $100. Penny has been is no more, so $100. Now we're moving on to Jjais Forde, another real estate litigator. Jjais Forde again has a wealth of knowledge. She's been admitted in New York State, in DC, in the Trinidad and Tobago. I'm sorry, one second. I think I was supposed to. Sorry, one second. Okay, I think I'm stealing actually Dr. Hurley's part. Dr. Hurley.
Yes. Well, bankruptcy, that's the way to save the day. I have the pleasure of introducing Jjais Forde. She's a real estate attorney specializing in foreclosure. So listen, without further ado, Ms. Forde, could you please present?
Hi there. Thank you so much. And it is an honor to follow Miss Angella Davidson and Miss Crystal Burden. And it's actually lined up very well because Miss Davidson and Miss Miller, if you're in Queens, help you at the very beginning, the onset of the trouble, help you hopefully get into a loan that will be affordable, but the expectancy of life is that things happen. So I often say it's the D's, the death, the disability, the disaster, right? That leads to not being able to afford your mortgage. And what I like to tell my clients is this is nothing to be ashamed of. This is nothing to be embarrassed about. This happens. It's life. So if you get into a situation with your mortgage and then now a foreclosure has been filed and you've gone through all the steps that Ms. Burden has beautifully outlined, now you're at the point where it's the last hurrah, right? There's that sale. And I sometimes feel like a little bit of a gladiator, but I swoop in at the 11th hour and I stop a sale. It makes you feel pretty powerful, right? I file that bankruptcy and I say, not today, not on my watch. But there are obligations when you're filing bankruptcy. So what I'm going to do is I'm going to take you through the steps by outlining the 3 different types of bankruptcy. And I'm going to try to simplify this because it is very complex. We've now moved from the state court into the federal court setting, right? This is the United States government. Things move faster than in the state court. So I'm still dealing with foreclosures that are still trying to get to sale, and the initial default was in 2006 or 2008, right? And that's the state court process. But when we start toying with the federal court, we cannot expect so much time. And there was a time when we could buy time for people to recover, but there are certain changes in the law with that, which I'll briefly speak about, that don't afford us all of that time anymore. But so let me dive right in. There are three types of bankruptcy. There's Chapter 7, Chapter 11, and Chapter 13. This is what you should be most familiar with. Now, Chapter 7 is a tool I usually use because we're being specific about foreclosure now. There's other debt that I can get rid of with bankruptcy. And of course, if you're in foreclosure, sometimes you do have other debt, credit card debt, and we can toss all that in there. But you don't have to be in foreclosure to file bankruptcy, but we're being specific today about bankruptcies that are necessary because of a foreclosure action. So there's Chapter 7. I implement that when there is no equity in the home. When the home is underwater, there are fewer expectations, let's say, if there's no equity in the home. And we can use a Chapter 7 because we want to enter the loss mit program in the federal court, in the bankruptcy court. So that loss mitigation program allows us to propose a plan to the creditor for repayment, and I'll talk about Chapter 13 plans, but this is a suggestion. When you're requesting for mortgage assistance, you can actually present something. A lot of people don't know this, but you can present something to the bank about how you can repay. But it does start with an application. You have to fill out a request for mortgage assistance. Now, in the bankruptcy court, eligibility for that plan requires two things: that you be on the loan, or somehow a successor to the loan. If you weren't on the loan, but your spouse was on the loan, or your parent was on the loan and you live there, and that you live there, that it's your primary residence. That's a requirement. Okay, it's not supposed to be used for an investment. There was a time when we could still sneak it through and the judges would work with us, but now they're being very strict. You've got to live there. There are ways that it can be determined whether you live there or not, but I won't get into all of that. If there is equity, we file either a Chapter 11 or a Chapter 13, and that depends on a couple of things. If you're an individual, we're looking to file a Chapter 13 ideally. However, if you're unsecured debt, that's the debt that doesn't have collateral attached to it. So your credit card debt, things like that. If that debt exceeds, or if it's just over $525,000, let's say, you're not going to qualify for a Chapter 13. Also, your secured debt, so your mortgages, let's say, it can't exceed 1.5. It's a little change there, but if you're over 1.5, you're getting dangerously close to not qualifying. So if you're over either of those limits, I've got to push you into a Chapter 11. We're going to save the discussion on Chapter 11 for last. It's complicated, it's expensive, but hopefully you qualify to go into either a Chapter 7 or Chapter 13. If it's a 1 to 2 family home and an individual loan, we should fall into one of those arenas. If you have equity, we're going into a Chapter 13. And before you file anything, though, you have to do a pre-filing course. That is a course that you take. There are various places that offer it, ranges from, I don't know, about $15 to, on the high end, $35 or $50 if you want all sorts of bells and whistles. But you must take that course before you can file for bankruptcy. It is critical. If you don't take that course before I hit send on that bankruptcy, it could end up with the bankruptcy being invalidated, dismissed. So we need that course beforehand. We can file emergency bankruptcies, though I don't typically suggest it. There is a reason for that at times. Sometimes you had your head in the sand, but you typically know about a sale 30 days out. That's enough time to hunt down a bankruptcy attorney, get documents together so that an organized approach to filing the bankruptcy can be made. So even though there's a strategy to filing in the 11th hour, and I may do that, I still would want to have all of the information prior so that I already know what I'm doing, right? Now, you've taken your pre-filing course. if there's been time, you've collected your documents as requested, and these documents are going to include tax returns, bank statements, pay stubs, information about your finances, what you owe, what your monthly expenses are, and what your income is. That's really the bulk of what we're looking for. Now, Chapter 7, Chapter 11, or Chapter 13, you are going to have something called a 341 hearing. This is also called a meeting of the creditors. So after you file, right, you're going to have to sign off on documents, schedules, and so forth. I'm not going to go too into that because it's the lawyer, and the judges will tell you it's very difficult to be successful in any of these without an attorney. So you should be working with a bankruptcy attorney. They know how to organize all that information into a way that the court will understand. But after you file, now you have the obligation of submitting certain documents to the trustee. Your case gets assigned a trustee. The 7 and the 13, there are various Chapter 7 trustees. There's only 2 Chapter 13 trustees. I'm not going to name them, but there are 2 Chapter 13 trustees. Chapter 11, essentially the United States trustee is supervising what's going on, but it's really the attorney that's doing a lot of the work that the trustee would do. The attorney's reaching out to creditors, the attorney. So that's why it's much more expensive. So, and it's not going to be, I should say that Chapter 11s are also used if you put your property into a trust or into an LLC, into a corporation, then Chapter 13 isn't an option and you have to do Chapter 11. So you should, if some people get advice, oh, you're in bankruptcy, you're in foreclosure, change ownership. That's for advanced tutelage, but I'm just going to say it's not the best strategy. You should not be doing that. And sometimes it's harmful and limits your options when you're going into bankruptcy court. So, but that's the advanced session. So since we're just at the beginning tonight of bankruptcy. So you have these tools. After you file, there's a trustee assigned, and then that trustee schedules a 341 hearing. This is also called a meeting of the creditors. This is an opportunity for your creditors to come forth and ask you questions. You're under oath. Your identification has been verified by way of your social security card and your driver's license. And the trustee is going to ask questions. Your attorney doesn't do a lot of talking here. They prep you to know what kind of questions you're going to be asked about the things in your schedules, about your finances. But the trustee is going to be asking you questions directly. After that, the trustee will do one of 2 things. They will close the meeting if they've gotten enough information at this phase, or they will request additional documentation and adjourn the meeting, hold it open, because when they receive that documentation, they may have additional questions. So, but that's just the beginning of the phase. Now, this is where we sometimes get the challenge. We file a request for loss mitigation program if you are eligible. A lot of people get tied up just in that and forget that they have to still work the bankruptcy. Now, if it's a Chapter 7, there's not much for you to do, because what you're saying in a Chapter 7 is, I can't do this, I'm liquidating, but I just want to save my house, right? There's no equity here. I just want to get a modification and stay in my house. So there aren't too many steps there. You can go into the loss mit program, submit the request for mortgage assistance, hopefully get a trial modification of 3 months or so, and then get a permanent mod. That would be the ideal situation in a Chapter 7. Chapter 13 is more complicated because now you've got equity. And in a bankruptcy, you're going to the United States government and saying, wait, stop, hold all my creditors at bay. I need to restructure my life so that I can pay them back. And this is a lot because they have a right to foreclose on you. They have a right to sell your property now, especially if you waited till the last hour and there is a judgment of foreclosure and sale and a sale date pending. So you're stopping their right, and therefore you have to do certain things. And one of those things in a Chapter 13 or Chapter 11, which are reorganizations, is to establish a plan. You've got to sit with your attorney and what is the plan? Now, part of this plan can be requesting loss mit. In the Chapter 13, it can also happen in a Chapter 11 if it is an expensive home and you live there and it's your primary, you can do loss mit in a Chapter 11 as well. So, but you have, in this plan, the trustee must get payments. So you have to start paying, even if you haven't paid on your mortgage since 2006. Now we've got to demonstrate that you can make mortgage payments, and you do that by paying into the trustee. Now, there was a time when the trustee could take 10% of these monies. The law has changed, and there's a rule that the trustee cannot, case law says the trustee cannot take any of the money if the plan doesn't get confirmed. So if the plan isn't deemed by the judge feasible, like this is going to work, then, and essentially the case gets dismissed and all the money gets returned to you. So the reason why I like this is that it's very structured and it's somewhat low risk, because you're able to demonstrate to the bank, look, I'm able to make payments of $3,500 a month, $4,500 a month. Some of my clients are making $6,500 a month. It depends on the size of your debt and what we're offering, whether it's a 40-year, 4.5% interest, 6.5% interest, whatever. But we're saying these are the payments we can afford per month. And look, bank, look at how I'm paying it into the trustee, so you can see that I'm doing it. This also starts to amass a little cash here, right? So a lot of times when you're requesting the mortgage assistance, if it's taking some months and you're building up a little reservoir there, the bank sees a little cash that they could have as a down payment towards your arrears and help in restructuring the loan. So that's also a benefit there. And most times they're not even looking to take all of that. And a lot of times they're not even looking to take any down payment, because they'd actually, as Ms. Burden said, rather work with you, get you back performing, as long as they can turn this back to a performing asset on their books and they feel that your hardship has been resolved and you're able to become stable again in paying them. That's actually enough, because people, the misconception is that I need to prove to the bank that I have no money and I cannot pay, and then they're going to give me a mod. And that is such a falsity. What you actually need to prove is almost as though you're getting another loan, right? The same way you conditioned yourself and proved to the bank when you got the original loan, I'm a secure person, financially secure person. That's what you're doing again. So there was a time when people thought, oh, I'm going to submit bank statements that say at the end of the month, I've only got $500 in there and I've only got $1,000 in there. So how are they getting their mortgage? I said, if you're doing a loan modification outside of bankruptcy, you're not paying a mortgage. So every month, your bank account should increase by the amount of said mortgage payment you say. So the first month, $3,500. The second month, $7,000. The next month, what is that? $10,500, and on so on and so on. So similarly, in bankruptcy, that's what they want to see, that every month you're making a payment. So after you've established a plan, requested loss MIT, submitted your request for mortgage assistance, hopefully gotten a trial. If you don't get a trial, a trial modification, there might be two other responses. One response can be an MDL, a missing document letter. They want more information. People get frustrated about this because the bank will keep asking for things, and they don't recall that when they were applying for the loan, similar things happen. The underwriter says, give me this, I want to verify this, give me another this. And, but then you're excited because you're purchasing a property, so you're giving them everything. Now you're frustrated, you just want a loan modification. But sometimes they do ask for things they've gotten before, or documents get stale because you have a certain amount of time, depending on the document. It could expire in 30 days, 60 days, 90 days. And if there's time in between responding to things, delays, then previously submitted documents will expire and you've got to resubmit. If you get a denial, then there's the opportunity to appeal. All of this can be done in the bankruptcy court. And I should say that it can be done in the state court. It is done during that mandatory conference that Ms. Burden talked about. That's your first opportunity to do that. If you miss it there, or even if you get a denial there, it's important to understand that you can do it again in bankruptcy court. We have judges, the judge cannot force any lender to give a loan mod. But the judges can use their power and influence in the court to make sure the process goes fairly, right? And we have some judges that are better than others at that, but it's another shot, excuse me, and it should be taken with fresh eyes, right? I get disappointed when people come to me and say, oh, I've been denied several times. And, no, let's start from fresh here. Your situation may have improved, and you look for ways that your situation can improve. Can you increase rents? Can you rent out a space legitimately? Can you get a second job? Can you come out of retirement? All of these things people have done to improve their financial situation. In bankruptcy with me, we take a complete look at their financial situation and we work to improve it. So that chapter 13 plan, that chapter 11 plan, you present it, you put in there that you're expecting a loan modification. And if everything works out in the end and you get the modification, or you're able to, if you're a recent defaulter, you may be able to spread your payments across a plan. And the plans start at 3 to 5 years. So ideally, maybe you can split the payments, your arrears, into 60 components. So if you owe $60,000, you're going to pay $1,000 each month in addition to your mortgage payment. If that is an option for you, then after you file, within 30 days, you make that first mortgage payment and you start making what's called post-petition mortgage payments to the bank. So you essentially resume paying your mortgage, and then you take the arrears and you spread it over a course of time. But this is more applicable to recent defaulters. With the mortgages that we have now, a lot of people, if they've been defaulted for 10 years, 8 years, they're not going to be able to spread that out over 60 months and pay it unless there's some lump sum that's coming in, some people are fortunate enough to be getting some sort of settlement from something or an inheritance, and they can use that to reinstate the loan. So that is the sum and substance of the bankruptcy process. The important thing to understand is that you have to work the program. You can't just say, I'm doing loss mitigation and I'm not paying attention to any of the obligations that I have to do under the bankruptcy, like paying the trustee and giving them documents as well. I will also say that there are some technical things with bankruptcy, and you'll find that some people become what's called serial filers. They realize I can file and stop a sale, and so they stop a sale, then they come back and they stop a sale. And oftentimes they've gotten bad advice. Your best opportunity is when you file that first bankruptcy to work it. Now, are there strategies? Are there times when you file but you're just not ready? Of course, it takes people many years sometimes to get into this problem. It can take many years to get out. But you need to work with good faith. You need to try. You need to go to the meeting. You need to demonstrate. Because if your case continuously gets dismissed, there's law that says after 2 dismissals without working it, a judge can find in rem, the creditor, just like Ms. Burden said about these creditors being sharks. They'll come in and file a motion for in rem relief, which is a relief that attaches to the property and says that you can't file bankruptcy again for however long it is. Sometimes it's a year, sometimes it's 2 years. In this day and age, where they're getting sales back on within 2 months, 3 months, if you're barred from filing again, your property may get sold. And it's not only the creditor can do it. If the trustee is frustrated with you coming in there and wasting everyone's time, they can file for a dismissal with prejudice, which also bars you from filing again. So you don't want to waste these opportunities. There's the most important thing, which I didn't name in the beginning, the thing that makes me feel like a gladiator when I stop the sale, is called an automatic stay. And the first time you file, that automatic stay stretches across the entire bankruptcy unless the creditor has good cause to come in and lift it. They have to come to the judge and say, they're not doing what they're supposed to. Please lift this stay so I can go on about my business and sell the property. But if you're filing for the second time within a year of a dismissed case, that automatic stay is only 30 days. Now your attorney has to do some more work, additional work, which is file a motion that must be heard within that 30 days to extend your stay, right? And it's very stressful to have to do that. If you can imagine trying to get something on a court's docket within 30 days of filing when everything else is going on. So, and now if you file third time within a year of dismissed cases, you will have no stay. So what that means is you don't even have the opportunity of running in last minute to file and stop a sale. You've got to try to get before a judge well before the sale is scheduled to ask the judge to impose a stay. And that's not a position I would want anyone in. So I think the moral we're taking from what is being said tonight is act sooner rather than later, right? Don't figure I'll file now and then, I'll just keep filing and eventually, I'll make good on these filings, because you may lose the opportunity to even have it as a proper tool. And the bankruptcy court understands that people are coming to them in distress. That's the whole definition. So you might not be ready right at this moment, but you have to have a plan. You have to tell the court, how are you going to get out of this? Right. So I think that I've hit all the heavy points on bankruptcy. It's a complicated system. There's a lot of rules, but I think I've given a summary that should be helpful, and I will remain available for questions. Thank
Thank
you.
you so much, Jjais Forde. Again, her specialty is bankruptcy. And when you're in search for an attorney, when you're trying to deal with these foreclosures, you have real estate litigators. You have to look for one who is specialized in foreclosure defense, because foreclosures has its own wild game. And if besides foreclosure defense, you have to look for an attorney whose specialty is bankruptcy, if that's what you want to file. Because many attorneys, they don't do bankruptcy. And if they try to, they'll probably get your case dismissed very quickly. So thank you, Jjais, for that. And we have a question that we'll pose to you at the end of the presentation. So now we're moving to, again, we want to make sure that you end up as winners. We want to make sure that you just don't give your house to the bank. We want to make sure that you save any equity if you're in a position like that. So now we have Janay Malloy. She is from the National Association of Real Estate Brokers, which is actually a national Black group that focuses on addressing housing problems throughout the United States. So I give to you, Janay Malloy. And I think
I'm here. Can you hear me?
Yes. Thank you, Janay.
Great evening. Thank you for having us and having such an amazing platform today. I've learned so much. I know many of these presenters on here. We've worked together in the past. I've seen them in action in court and other spaces, and I'm thankful. I want to apologize. I'm in the airport, delayed. So my apologies that that's where I am, and you're getting you might overhear the announcements. Okay, guys, but we're gonna rock through this. So my name is Janay Malloy, and I am a real estate broker licensed in New York State, and I am a regional director, regional vice president for the National Association of Real Estate Brokers. NAREB is what I like to refer to is the nation's best kept secret. We were organized in 1947, but some of our boards are over 100 years old, and we focus on creating what we call democracy in housing. We were the nation's first real housing advocacy organization. Right, we are the catalyst. We are the catalyst for fair housing legislation, sidestep with Dr. King, and making sure we got this legislation passed. So we go back a really long way, and we focus on, and primarily we got this started because we wanted to build Black home ownership, and we still focus on that today. And we focus on development, home ownership, getting people into appraisal, open up career opportunities. So it's a list of things, but primarily, like Ms. Dudley said, we want to focus in this conversation on helping you keep your house at best. If not, what is the last resort? Right? And each one of these speakers has given you a great list of things. And I'm going to start with the short sale process, only because a lot of what everyone else has said, the short sale process kind of mimics that process, right? A lot of those pieces are consistent. So what does that mean? A short sale is when you have exhausted pretty much everything that everyone else has said, and you're like, now what do we do? Right? We want to sell the house. We don't want to get foreclosed on. We want to kind of get from under this thing and how to get the cleanest start as close as possible to a clean start. So a short sale is when you say to the bank, your house, you may have purchased at a price where now it's not, it doesn't equate to that price anymore, right? You purchased it at, I don't know, at 500 or 600, and now maybe it's old, you haven't updated it, there's damage to the property, the valuation is down, you purchased at a really high end of the market, or you got a really bad loan. Any of those things could mean why you're now at a price where you really can't sell the property for what it's worth. And you're saying to the bank, hey, meet me in the middle here. Meet me in the middle. We're gonna find somebody to buy this property, but they're not gonna buy it for the price that I owe you. And we're asking the bank, actually, I always tell people to think of it like you owe them some money and you about to short them their money, right? Like that's really what it's like, right? You owe them something and you about to say, hey, look, cut me a little slack here. And that's really what it kind of looks like. But there's a process to that short sale. And I'm going to say something contrary to what the other speakers believe. I believe that the banks do want your property. I'm watching the data. I believe there's an attack against private home ownership in this country. And I am of the belief that the banks do want your property. And that's why they're denying short sale. That's why they're running so hard against the people that are trying to do foreclosures. They're being super aggressive. And I believe that aggressiveness is because they do want the property. A lot of these banks are keeping the properties. They're reselling them to corporate buyers. It's a friend circle, in my belief, right? And I could be wrong, but I also could be right. So that is my belief. So that's why this information is necessary and important for you to really follow and listen to every person that has spoken to you today. Don't be afraid. That's where we have to make sure we get out of. And tell your friends and family, have this conversation with someone else. Just share. You don't know who's in trouble. Everyone's not going to tell you they're in trouble. They're not going to speak. They're embarrassed. They're ashamed. Like we said, they're ducking their heads in the sand. So just have the conversation, not about, hey, are you in trouble? But, hey, listen, I was on this excellent Zoom, and this is what they shared. And there's resources for you, right? So the short sale means now you need to negotiate with this bank. One of the first steps I like to say is that you really got to pick a team. Right? This is a team sport. Everything everyone's talked to you about is about who's involved. This is a team sport. It's not to be done alone. And in the short sale process, the team is really going to be your real estate agent, right? Your attorney, and you got a select few around here. You got some few that select from the real estate attorney, and probably your tax strategist or a tax advisor as well will be your team. And when it comes to actually doing a short sale, because they also all have information on how this thing is actually going to work out for you. You're going to need that team to get through this process. And I would say from the beginning, pack your patience. Right? It's an oxymoron, short sale. It never happens fast. It's not short timing. It takes a while, and it's going to take you to pack your patience and really center yourself around what is going on in this space. This thing really starts out with us saying to the bank. I think someone else mentioned, I think Madam Forde mentioned you got to do an RMA, right? So that's called a request. Oh shoot, I'm sorry. Right, so you're asking them to say, hey, help me, right? I'm asking you to help me with this process, and with that asking for help, they're going to send over a package. Each bank has their own package. And they're going to send over a package, and it's going to tell you, here's what we need. We need pretty much everything that everyone else says. We're going to need your financial information. We're going to need to know, where you're working. Are you working? What send us your bank statement. They're going to ask for a series of things, and you have to submit those series of things. So that's to be clear, right? It's not like you get to pick and choose because that's what they want. You have to submit it. And you have to submit a hardship. They're going to ask you also for a hardship letter. They're going to say, what happened? What had happened? How you get here? What happened to the situation? Tell us. And you're going to have to explain it. How did you get here and what happened to the situation? Also with that, we're going to be submitting, from my side, my job is now to submit what we call I need to submit what I think the pricing is for the property, right? Like where it is right now and what they could possibly get for it. In choosing your team, you need to choose an agent that understands how to price the market, right? So you just have conversation. People say, tell me about how you price the market if you're looking for an agent. Tell me how you, what are the comps in my area? What a property is going for? They need to understand how to price the market, and also particularly price your home, because your home may have an obsolete something like, I don't know, not really well. Like there's a leak in the roof. There's a, the boiler's busted. There's a gas leak. There's like an oil leak. You have oil tank leaking, stuff like that. And those things, there may be lead, there may be asbestos in the house. So they have to understand how to really price your property to do this effectively. So they're gonna say, okay, we're gonna put together this opinion of what we think the price is worth, the property is worth, and submit that also to the bank of what we think it should be offered as. They in turn are gonna send out what they call their own BPO agent, broker pricing opinion agent, who's another real estate agent typically, is gonna come out and determine what they think the property is worth. So we don't have the last word in this thing, right? It's not like in a regular sale where you have the last word on whether or not what happens with your property. In a short sale, you don't have the last word. The bank has the last word on whether or not they're gonna move forward with what you're agreeing, what you want to sell it for, right? So I think that's what some people really miss. If they don't get, you kind of lose control, you have less control here, right? That's just what you actually given out. So when they send out this person, they're gonna tell them what they think the house is worth. We're also gonna be marketing the property. The agent's gonna market the property. They're gonna probably they can do an open house. They can probably sell it to an investor. Maybe there's an investor that wants to purchase it, especially if it's not in good condition. But you have several options on who may purchase this property. You're gonna you're gonna agree on a price, and you're gonna go into contract with the person. Now, here's the deal. All parties to the mortgage and all parties that are on the deed need to be available in this process, right? I have people say, hey, I want to sell my house and they want a mortgage. They're not on the deed. Or they want a deed. They're not on the mortgage. This cannot work, people. This cannot work. All the parties got to be partying together, okay? So let's make sure that we're paying attention to that. So if you got to make nice with your ex, make nice so that they come to the table and they're willing to play, okay? Because otherwise you're not going to get from under this thing. That's just, or that becomes another court proceeding that you do not want to go through, right? So it's them to come to the table. That's not something that we want to have to deal with. So that's something to really be aware of. If and when we find a buyer, we're gonna go to contract, which is just like any other sale. You're gonna go to contract. We're gonna submit that contract. The bank is gonna review it. If it's an LLC, like a corporate investor that are buying your property, they require a lot of documentation from the LLC as well about their business. So we're gonna submit that to them. If it's a private buyer, they're gonna be like a private individual, like your neighbor buying or down the street buying. They're gonna require, hey, do they have a pre-approval? They have to prove that they can buy this property as well. Just like you had to prove that you could buy the property when you would, right? They're looking to make sure they're getting into the right deal. So they need to know that information. If their BPO match, their broker price opinion matches up, all is well. Typically, we're gonna eventually be looking at going to a closing on this property. At some stage, I've made some notes, but of course, I'm not even paying attention to them, right? Here's the deal. One thing I didn't talk about, if there are any liens, judgments, I typically run a title report, which is basically a report that looks at you and the property before we even get into this deep depth conversation, because we have to see what is owed on this property, right? Did you run up a $30,000 water bill? Do you got liens? Do you got parking tickets? Do you got judgments? One lady told me, I got no bills, and then she had $100,000 in IRS tax. Just got another case. They got $275,000 in sales tax, right? And they telling me they ain't got no problem. You got some issues. And we can verify how these issues get paid, because these issues are now, some would say, attached to the property, right? You can't just go to the closing table without dealing with these things. And some of these things can get negotiated within the short sale. The bank may absorb some of them and pay for them. Sometimes they will not. They will tell you, I'm not paying for that. That's your business. You pay for it. right? They can deny it. Everything is not that. They're gonna take it and take it under consideration because they want to make money still on this note that you pay, that you sign. So we want to be clear that we do run that report ahead of time, just to make sure what we're actually negotiating, because we have to actually fill out documentation for the HUD one. We fill that HUD out, which is basically it's an accounting of everything that's attached to property, accounting of the real estate fees, accounting of your transfer fees, accounting of everything that's gonna go on with that property, pretty much. We have to say to the bank, hey, this is everything that you're gonna pay. Here, this is the amount of money that the contract is for. Here are all the minuses, and this is what you're gonna get in the end. And the bank has to agree to that number that you're gonna get in the end. And they gotta be happy with it, right? And you're not entitled really to get any money unless it's money that they approve. So let's get clear on it, right? You can't sell a house typically to your cousin or your husband, right? They're gonna ask you to do something called an on-plea transaction disclosure, saying that you're not getting a bailout from your cousin or your sister. So these are things we have to be aware of. There's so many things, and I'm not gonna belabor it, but you should just need to be aware of that. Pack your patience. At some point we get through this thing, they can either approve it or they can deny it. Right? Lately, to me, they've been in the business of denials. But I'm in the business of approval. So with my lovely attorney, we go to bat for it. And I heard attorney say, you'll never get this done. And I love when attorneys or anyone tells me that, because you know what? That makes me just work harder. And we usually come out very successful in the files that we've had to work with, and working together with your attorney. You're gonna go to, when we get this thing approved, you're gonna go to the table with your attorney, and they're gonna help you close this thing. The bank is gonna make you an offer. There's gonna be paperwork you're gonna have to sign. The attorney is gonna make sure that that paperwork that you have to sign says the right thing. It's not your real estate agent's job to determine that paperwork. I wanna be very clear. We don't write contracts in New York, and we don't determine that paperwork. Your attorney will look at that paperwork and say, hey, it says that this is what we're selling the property for. It says that, you're gonna get X amount, maybe you're gonna get some like moving money. We're gonna call it that. You're gonna get some moving money. You're not gonna be liable for this in taxes. Because sometimes that difference, right, that you owe them 6, we're only gonna get the house selling for 5, that's $100,000 difference. They can hold you accountable for that and send you a 1099, right? And then you can owe taxes on that money. So your attorney is gonna help you make sure, and your tax strategist is where those people come together to talk about whether or not that makes sense, or how can we negotiate that away. Oftentimes we can negotiate it. Sometimes it's not a stuff in service that they don't want to negotiate. They just don't want to, right? So I'm just letting you know that those are all the things you need to look for if you're not working with one of these attorneys on here, and someone else is like, hey, come over here. Let me show you. And they don't know what they're doing, right? You may get stuck with some of that stuff. So just be aware of that. It's very, very important. You don't want to show up next year with $100,000 bill tax, right? So just be conscious of that. Again, always pack your patience. It can have a credit impact on you, so you want to be aware of that. So just talk to them about that. Your credit person or your attorney. Yeah, and you're gonna always need to stay with all your documents organized, right? Because they can ask for updated documents. This is a long process. We ask for a third-party approval, say that you give us permission to talk and get information from the bank. Guess what? We're gonna have to update every few months. Your pay stubs, they're gonna ask for that. They can ask for that to be updated. Keep all your information. I just tell people, keep submitting them. Keep submitting them to me. Keep sending them every time you get paid. Every time you get a bank statement, just send it on over. We got a file, we dump it in, and every time we need to send it over, we just send it over. This is a system. When you have a system, this thing works better. Guys, not willing, we get this thing approved, we don't get any rejections, we go to closing, and guess what happens? You get to start a whole new life. You get to breathe again. You get to woosah for a moment, and you don't have this debt on your head, right? And guess what? There is a start over. That's what I always want people to know. Start over is possible, right? It's not the end of the world. None of this is the end of the world. We're still living, we're above ground. My uncle says you're above ground, it's a good day, right? So you're above ground, it's a good day. We got a chance to start over. And that's really, I guess, the gist of the structure. And there are other pieces, right? I can get deep in the weeds with this, but I think that really is the basis. So you don't really walk away with anything, but you walk away with your credit not being full. You don't walk away without this. So you walk away without the foreclosure, so you leave that behind you, and you walk away with a better place to start. Fair enough? And your lenders can tell you when you can repurchase again. I always encourage people, don't give up, right? You may get just to get everything on track, and there may be another chance for you to repurchase. Maybe you need something smaller. Maybe you need a co-op. Maybe you gotta shovel snow and take care of roofs and the stuff and the God knows what, right? Who knows? But the space is there for you. Now, here's the best part. The best part is what most people give up. They don't know. They bought their house 15 years ago. Most likely, if you bought your house 15 years ago, guys, guess what? Because if you do your city, it's on fire. You can make some money. You got some equity, right? And that means that whatever you owe the bank, your house is actually worth more than you owe the bank. That difference is called equity. Now, if you got some equity in your house, again, we need the same thing. You need a team. You need your attorney, right? You need your tax strategist, and you need a great real estate professional that's gonna go in and say, hey, and again, what I also like to do when we're looking to help you sell your house, I love to do an appraisal beforehand. I only do my thing, I do an actual appraisal because I want to know what this number's really looking like, right? We're gonna determine what that valuation is. We do the lien search as well in advance because we need to know if there's anything sitting out there. Because again, if you were in trouble, you may not have paid any. You may have missed paying the mortgage, any liens or stuff that have come out. So we do that title search as well in advance, right? Here's the deal. All the processes are very similar, except you're now not submitting to the bank all this information, to your lender. You know, you don't have to submit all that, right? What you do have to do is prepare to move. That's what the most important thing. You need to get ready to get out of here. My job is to make sure I'm gonna call the bank and say, hey, listen, how much does this person owe you? We're gonna still need that third-party authorization. I'm gonna figure how much you owe. We're gonna figure out there any items that you owe anybody else that can get attached to the house one at a time, report. And we're gonna still do that high because I need to know what the numbers look like. And we need to know how much you're gonna net at the end. So that equity, we're gonna deduct all of that and figure out how much money now is coming to you, not the bank. You are in control in this process. That is the biggest thing ever. You are the one in control. Right? And you're going to be able to walk away from that property with some money in your pocket. We're going to do the very same thing. We're going to show the house. We're going to market the house. We're going to now, we may have some open houses. Then it's a whole marketing campaign any real estate agent can talk to you about in detail of how they do that, how effective they are in sales, and how long the property should be on the market. We are very quick. We like to get it in, get you in and out, get things closed, and get you, again, onto your next level, right? So people, if you're in distress, it's like you're like they're in headlights, right? I forget who said this. Like they smell the blood in the water. I'm finishing up, right? I got 2 seconds. There's blood in the water. People smell the blood in the water. If anything has been filed, people smell the blood in the water. They're going to be knocking on your door, calling you. They're going to be super persistent. You got to be as persistent as they are. You got to be that persistent to keep your house or to fix your situation or find the best solution for you. Don't be afraid. Don't be intimidated. They are bullies out here. That's what they do. They're professional bullies. I'm just letting you know. So when they come bullying you, you just know they're professional bullies and you're ready for them because you got a team right here that can back you up. These people got 8 million degrees. You know how many letters they got behind their name? They're ready for this. They were built for this. So don't be afraid when it happens, okay? Get a good team, talk to them, interview them. Simple 2 questions. I tell all my clients to ask an attorney, a loan officer, a real estate agent. Tell me what you do and how. Tell me what you do for me and how much will it cost? Those are pretty basic questions. And you just shut up and listen. And you do that with a few people. Now don't waste time. I'm sorry, can you hear the old lady? I don't know that. Don't waste time. You gotta be aggressive the way those guys are aggressive in this process, right? Finding your right team, ask for assistance. Don't jump in an investor telling you they're gonna pay you. I'm gonna give you cash. They coming to the table with a check. Some of them are getting a mortgage the same way. There's a different type of mortgage. Most of them are not coming to the table with a bag of cash anymore. It was a time they did used to show up at the door with a bag of cash. They're not usually doing that. Listen, get the professional advice, then decide what strategy you want to use to win in life and start over. There is always new space for you. I want to encourage you, keep your patience, keep your faith. You can win in this space, okay? And thank you so much. I appreciate everyone on this call, Yvette. God bless. I'll get your questions until my flight takes off in
Thank
about
you.
20 minutes.
Thank you,
Thank you,
Janay.
guys.
Thank you, Janay. Thank you for being in the airport and telling the pilot to hold up until you finish this portion. I really appreciate it. So without further ado, we're moving along to Lori Miller. And we're going to drop her bio in the chat just to save time. But Lori Miller is the Executive Director of the Neighborhood Housing Service of Jamaica. So she's holding down the Queens end. We have Angella Davidson holding down the Brooklyn end. So Lori Miller, she will speak a little bit on foreclosure rescue scams and bring this program home.
Okay. Thank you, Yvette. Good evening, everyone. Just wanted to say there's been incredible information shared today. And what is most important, I think, about what we're doing is that this information needs to get out to all those homeowners who are at risk. I think one of the most important things I heard today that I wish we could get across to people is that they should not give up. Just because they're behind on their mortgages and they're facing foreclosure, there are many, many resources out there. But as both Crystal and Janay mentioned, there are sharks in the waters, and they, as soon as they smell blood, they're after these folks. As if it's not bad enough that you are behind on your mortgage and possibly facing foreclosure, to have these people, you know, who are scammers, this is how they make their living, and they prey on our homeowners. Foreclosure rescue and loan mod scams are on the rise. A few years ago, the Attorney General's office implemented a program called, it was Homeowner Help Desk, Protect Our Homes, and NHS Jamaica and other nonprofit housing groups and legal services groups were part of that. And our goal was to get the word out to homeowners in targeted communities. And the targeted communities tend to be communities of color, low and moderate income communities, and communities where people have limited or or don't speak English. So, our immigrant communities. And these are the folks that are often targeted. What we are also seeing is that where it used to be primarily Brooklyn, where we used to see things like deed theft and other scams, with the rising prices in Queens, and our target area is Southeastern Queens, we have also got a bullseye, on our backs. And so there are people out there, who are constantly targeting these communities. They look for people who are in foreclosure. What they do is they've got people who spend their days searching public records to find out, who might be going into foreclosure. Like I said, they target certain neighborhoods. They send you mail. They have ads on radio stations and TV, the internet, and they will bombard homeowners with phone calls. And as Janay said, actually they'll show up at your door. So it's a very stressful time for people. Most folks, are not, they're not educated about what their options are. They may also, often they're not aware of the scams that are out there. So one scam is the most common one, loan modification scams. These scammers may be individuals, they may even be attorneys or companies. And what they do is they tell the homeowner that they can guarantee them that they'll get them a loan modification with lower interest rates. That's not true. Organizations like NHS of Jamaica and NHS of Brooklyn and others, who are, HUD certified agencies or legal services providers, we cannot guarantee that, but we have the experience to work with these homeowners. But we make it clear to them that, they need to do everything that we ask them to do. They need to do everything that the bank asks them to do, but still there's no guarantee. So anybody who guarantees you that they can save your house is not telling the truth. What a lot of these scammers will do is they demand a substantial amount of money up front. We'll represent you. We have homeowners who have come to our organizations and they have paid thousands of dollars, to these foreclosure mills. And find out that nothing has happened, nothing has been done for them, and they come to us. And that's when they find out that groups like ours are funded by the New York State Attorney General. The Crystal referred to HOP, which stands for Homeowner Protection Program, and that funds various groups to provide foreclosure prevention assistance to homeowners. People pay a lot of money, thousands of dollars. There's some scammers who will they claim that they're making it easier for you. So instead of asking for all the money up front, they will actually get you set up so that they can make automatic withdrawals from the homeowner's bank account. That is definitely a no-no. And it's actually illegal for these companies to charge you up front. There is a law that says they can only charge you, or should only be charging you, after they have done the work and they've secured you some sort of resolution, whether it's a modification or some other solution to your issue. They should not be getting money up front. They collect money from people. They say that they're going to represent them in court. Homeowners then find out that they have never done anything. And that's when they find themselves, often in even worse situations. And hopefully they'll find out about organizations like ours and come to us. But at that point, they have been put in greater jeopardy. Some scams, there's a forensic audit scam where they'll say, for a substantial amount of money, they will have someone audit the loan documents, supposedly, on the premise that there have been some improprieties or in the actual process, of securing your loan, and have people think that, possibly they'll be able to get their mortgage discharged. We've had people come to us that said, I was told by someone else that, something that wasn't quite right with my loan. And so I should be able to get my mortgage, get out of this mortgage entirely and just own my house. That doesn't happen very often. And if it sounds too good to be true, people should really believe that. What we see a lot more of in Southeastern Queens these days, is deed theft. As I said, because of how much houses are costing now, many of our homeowners have been in their homes for a number of years and their homes have appreciated significantly. These scammers will trick a homeowner into signing over their deed. So basically, they're transferring ownership. They will claim that they can resolve the foreclosure, they can reduce the mortgage debt, or that they're refinancing the property. And in actuality, they're getting a homeowner to, sign that ownership over to them. What they will then do often is they will get a straw buyer, which is someone else who's affiliated with them, who will take out a mortgage. They're going to take out a mortgage for more than the homeowner currently owes on their mortgage. The homeowner will still be responsible, for their mortgage if it has not been satisfied. Often they don't satisfy it, but they can either take out a new mortgage, pay off the original mortgage, and they're going to walk away with that homeowner's equity. There are people who have had someone knock on their door and say, "I'm the new owner of this house." And people didn't even know that they were no longer the owner and that somebody else had the right to sell their house or refinance it. So it's important for people to know that these things are out there, and the sharks, will not let up on them. They're going to try and do anything and everything they can to get their property. And they'll tell people that their situation is hopeless, and that's not the case. As you've heard tonight, there are many things that can be done to try and save someone's house. How do you avoid rescue scams? There's some red flags. For instance, the making guarantees. Nobody can guarantee that they're going to be able to get you, a modification from the bank. Requesting payment up front. Again, you should not be paying for services, foreclosure prevention services from NHS of Jamaica and NHS of Brooklyn and other organizations, the legal services providers who are funded by HOP. Those services are all free. We don't charge, for anything. So if people are in distress, they need to be directed to come to one of us. And, there are things that, let's say in NHS of Jamaica or NHS of Brooklyn, are not able to do. If someone needs legal representation or needs to be referred to some other resource, we will make those referrals. And that's what's important for people to know. Our interest is really only in helping people keep their homes, and to the extent that it can be done, to make keeping that home and living in that home more affordable. Often these scammers will present people with documents that are confusing. They don't understand, what they're being asked to sign. But again, we're talking about people who are desperate and someone has sold them, a bill of goods. People should never sign any documents that they do not understand and they have not read. Back in the days of the foreclosure crisis in New York City, and specifically in Southeastern Queens, many people just signed whatever was put in front of them, and they had no idea, what the terms of their loans were. When it comes to something as serious as foreclosure action, trying to save your home, as has been said many times tonight, it is best that you work with a housing counseling agency like ours or with an attorney. Don't sign anything. We ask that, homeowners, even if they, advocate on their own behalf with the banks, if they're not clear about what's being offered or comfortable, they should come to one of us and say, can you review these documents for me? Often people are advised to stop making payments. They should never stop making payments. There's situations, depending on where they are in the foreclosure action, where the bank may not accept payments. But if the lender is accepting payments, then you should continue to make payments. As Crystal said, be really proactive, be responsive when your counselor or legal services provider asks you for something. Try to get us that information as quickly as possible. Same thing with the bank. Do not cut off your communications with the bank. People are often advised to just, leave everything to me. This is the scammers. Now, if you think you've been scammed, there's some things that you can do. You can file a complaint with the New York State Attorney General's office. You can go online. They have information online. Just, type in New York State Attorney General's office. They will tell you, how to contact them. You can, file your complaint online, or you can actually print out a form and mail it in. As Angela said, the Consumer Financial Protection Bureau has been gutted. You can also make a complaint to the Federal Trade Commission. And if you don't know where to go, come to one of us and ask us what to do. Again, people can get free help from a legal services provider. And if they happen to be a victim of a foreclosure scam, or they think that they might be, a potential victim, again, they should come to some of us, especially a legal services provider, because there are laws, for instance, the Home Equity Theft Protection Act, which can cancel a fraudulent sale of someone's home. The homeowner may also be able to sue for damages. If they are a victim of a loan mod scam, they may have rights under the New York real property law that can also allow them to sue for damages and attorney's fees. And again, lots of agencies out there, free services. You can go to the HUD website, the HUD.gov website, and look up nonprofit housing counseling agencies. Homeowners can call 311, which is the city's helpline, and explain what their need is, and they will refer them to an organization like ours or others. And there's also an intermediary agency in New York City that we in NHS of Brooklyn belong to, and that's the Center for New York City Neighborhoods. And there is, there's a group of both housing counseling agencies as well as nonprofit legal services providers, that they advocate for. So you can always call them and they will direct you to an agency, in your neighborhood, if your preference is to actually deal with someone in Queens or Brooklyn. And again, HUD, it's important, I think, to let people know that HUD approved housing counseling agencies, are a tremendous resource. And again, what we don't necessarily do or offer in terms of services does not mean that we cannot help you get to where you need to go and get to the resources that are available. But more than anything else, just as we have found over the years that pre-purchase counseling makes for more stable and successful homeowners, it's important for this type of post-purchase counseling to help people who work so hard to get into their homes be able to keep their homes and hopefully make them more affordable. And that's my presentation. Thank you all.
Thank you so much, Lori. Thank you so much, Lori, for providing us information on what we can do to save our homes and to be aware of the rescue scams. Remember that Ms. Burden talked about that the first step in the foreclosure court process is they file a list pendants against your house. So those investors, it's a public document. So those investors, they buy those list pendants lists. So as soon as your house goes into foreclosure, they buy the list and then they start knocking on your doors, trying to get you to transfer the property for free, basically, to them. I did want to bring up just two quick issues. On reverse mortgages, we didn't bring that up today, but on reverse mortgages, that is a very unique way to actually save your home. If one of your parents or your grandparents had a reverse mortgage essentially is a negative amortizing loan. So you take out a loan from a bank, and instead of making those mortgage payments go on top of the money you borrowed. So easily that $300,000 loan could reach $700,000 very, very quickly. But when that borrower dies, and when the borrower dies, that bank wants all their money right away. So they have a certain amount of time that they have to give that survivor, that family member, time to pay off that loan or sell the house. And if they don't, then the bank could start a foreclosure. But if you are related to that borrower, if you are a child or you're related to that borrower, you can save that home and keep that home in the family. That bank, by federal law, is mandated to give you the property at 95% of the appraised value. So if that loan is at $700,000, call your bank, say, I'm related, I am a son of the borrower, I want to save the home, I want an appraiser to come to the property. They'll send an appraiser to your property. Whatever that appraisal says, they have to allow you to pay them off at 95% of that appraised value. So now I have a $700,000 loan. The appraisal comes in at $500,000. That bank has to give you the opportunity to pay them off at $475,000. So you run out, you get a mortgage, you refinance that debt, and you save that family home. That's a reverse mortgage foreclosure. So many people throw up their hands once they see this the reverse mortgage balance going very, very high. Please don't do that. Please talk to a HUD counselor, an NHS counselor, or an attorney, or come to the Du Bois Bunch Center because you can save that home. Lastly, someone brought up a question about surplus. Ms. Burden talked about that you have an auction. That's when the bank sells your home. But when they sell a home, you have investors bidding on the home, going once, going twice. When that price is higher than what you owe the bank, then they have to deposit that difference with the court. And you as a homeowner have a right to make a claim against that money. Now, if you owe a second mortgage, those people are also going to make a claim, but don't let that money go. And don't hire the people that's going to take 1/3 of that money just to get your money back for you. Again, see an NHS counselor, come to the Du Bois Bunch Center, or see an attorney, but you have a right to make a claim against your own money and get that money out of the court system. Okay, so to discuss surplus. There was another question in the chat. I think I sent it to Jjais Forde.
Yes.
Yeah.
You want me to address that? Let
Yes,
me
please.
see
Thank
what
you.
it said. I think it was, what happens if what if the Chapter 13 was approved and the owner still doesn't pay and it's been 2 to 3 years? So I think what's being asked is, if you get a loan mod in bankruptcy, you get your Chapter 13 plan confirmed, which is approved, and you're paying into the plan for 2 or 3 years, and then something happens, and forgive me if that's not the question, you can correct me if I've misstated it. But once you're in the plan for 2 or 3 years, there's a push to try to get you to finish the plan, because there's only, you're halfway through essentially. So you really want to try to stick with the plan. But if you don't do it, you're not going to get your essential discharge and your loan reinstated. If it is in fact, because if you're in a plan for 2 to 3 years or 5 years, it's 3 to 5 years. If you're in that plan, that means that you're reinstating. So your push is to try to reinstate. If you got a modification, you're not going to be in bankruptcy for long. You're going to have your plan confirmed, and the plan would have been and then the approval of the loan mod would take place at the same time as the confirmation, and then you'd get your discharge from bankruptcy. So the bankruptcy would have been successful, but you'll go on to have a new loan, have new payments. So if you default again, they go through the foreclosure process again. But if you have an arrangement to reinstate over a period, you really want to try to honor that. Because if you don't, you're essentially starting from scratch and you still have the foreclosure on your back. Okay, so if you get a loan mod and you're in a new loan mod, that cancels, a permanent loan mod cancels the foreclosure. And they would have to restart foreclosure if you were to default. But if you're in a plan to pay off arrears and you default on that in bankruptcy, they can go forward with the foreclosure. They can move to lift the stay and go forward with the foreclosure. I hope that answers the question.
Mhm. Yvette, I wanted to add, just in reference to reverse mortgages, NHS of Jamaica, doesn't have a certified counselor, but we've referred people to the NHS of Brooklyn, because if you are a senior, and we are seeing an increasing number of seniors, who are behind on their mortgage coming to us and they're on fixed incomes, we refer them to NHS of Brooklyn. So, you may want to say something about that, Angela. Of course, that works for seniors. Or could.
Yes, thanks, Lori. Miss Dudley did say better than I can, but I do work with homeowners getting reverse mortgages for the first time or in default on a reverse mortgage, or someone has died and then they need to get out of that reverse mortgage. So everything Miss Dudley said, you have 1 year after someone dies to pay off that debt, but you have it in 2 tranches. You can ask for 3 months, then another 3, and then 6. We've seen people who are in default and reverse mortgages for over 5 years. And we're not saying to do that, but it's a process. And, as with everything that was said here tonight, we're here to assist you through the process. If getting a modification, which someone can get a modification, you can become a successor in interest after someone dies. And or you can purchase the home, although it's your own family home, as Miss Dudley said, for 95% of the appraised value. So I am here, NHS Brooklyn, if anyone has questions regarding reverse mortgages.
So, Angela, I was referring to the people who are, who are facing foreclosure,
Okay.
who can save their homes by taking out a reverse mortgage.
Okay. Thanks, Lori. Yes. So we use reverse mortgage as another option to save your home. So if you're someone of a certain age, start with 60 years of age for non-government loans, and 62 for what is called the homeowner conversion equity mortgage. HECM mortgage, which is government backed and FHA secured, 62 years of age. So if you're someone who's in default on your mortgage, we can oftentimes, if there's enough equity, get you a reverse mortgage, although you're facing foreclosure, to get you out of that loan and for you to be able to stay in your home. So it's roughly a refinancing of that debt. Get you a new debt. And that's the only time you can refinance a debt, when a loan when you're in foreclosure. It's through a reverse mortgage.
Yes, and it's a great tool
Yes.
for people of a certain age.
And just one more thing, we have for co-ops now. So 2 years ago, Department of Financial Services allowed for reverse mortgages on co-ops. It's not government backed, it's private lender, but it's available. And that one starts at age 60, and they have higher loan limits for that one. Thanks.
Okay, Janay Malloy has her hand raised, and then we'll move to Crystal Burden. And then we also have a question in the chat after Crystal. Someone is asking, what is a reinstatement? So anyone can hop in and address that. So Janay?
I'm glad you guys addressed the reverse mortgage as an option. I know traditionally in communities of color, particularly Black communities, people are definitely afraid of the reverse mortgage. They've heard so many horror stories around it. But I will share with you that the reverse mortgage, with or without distress, can be an amazing tool to be used when used properly to pass on legacy money in our communities. I think it's something like 90-something% of reverse mortgages, number one, are not done by like me Black folks, right? They're done by people who understand strategy and passing on inheritance and passing on money. That is very clear. The HECM and the reverse mortgage. So when we get these strategies out, maybe one day we could do a workshop on how to actually strategize with the HECM and reverse mortgage to educate our people in advance how to use these strategies to come out on top versus being subject to them in the end. And I have a great person that does like that. We can talk to them and does an extreme presentation on that. And it's good to do it to stakeholders in community so that they can begin to understand this, right? And be able to share it now with the people that they're engaged with in community.
Thank you, Janay. Crystal, Forde?
Okay, I have a question for, is it Jjais? Jjais? Okay, may I call you Jjais?
Yes, of course.
Okay, good. All right, so with the bankruptcies, if a borrower is discharged in bankruptcy, they can only file bankruptcy after it's been discharged every 7 years. Is that correct?
Correct. So, right. But there's a caveat to that because I have some strategies. So, as I said, sometimes, and we're not recommending this, you try to move quickly, expeditiously when you're trying to repay this creditor and get out of this situation. But sometimes you need time, right? And then it becomes my job to buy you time, not to evade your creditor, but to rehabilitate yourself so that you can pay your creditor. So there were times when the economy was such that the property was underwater and I could file a 7, we could get rid of the rest of your debt, rehabilitate you, and because your 7 worked, the next year I could file a 13. Okay, because it's the dismissal and you're allowed to discharge in 7 and then you can still do a 13. So I don't have to wait 7 years to get to do a 13 if you were discharged in your 7, right?
Okay.
So I would file twice for you and then we're planning, because what would happen is now maybe the property is worth more. Maybe there is equity, but even if there isn't, I could still take you into a 13 and make a plan. So I would start with a 7 strategically if you had no equity, because I know I'd get another bite at the apple with the 13.
Got it. So it's 7 years depending upon under what chapter you file.
Correct. So you have with the chapter 7 too, if you get the discharge in the chapter 7, remember that automatic stay I talked about?
Yeah.
You could file that 13.
Stay?
Say again?
Is it 341 stay?
No. The automatic stay is what stops the foreclosure sale. It just stops all your creditors. Nobody can do anything. So when I told you that if you file twice in a year with dismissals, you're reducing the amount of your automatic stay. But if you work your 7 and you get a discharge, that's a successful bankruptcy. After you get that discharge, I could essentially file a chapter 7, within a few months or even sooner, but usually a few months because you're recovering and I still get the full stay because you've been using the system properly. But the limits to your stay happen when you're filing and not working through the system. You're just filing to stop the sale and then you're not doing anything. So if that's in close succession within a year, you start chopping away at your automatic stay, which is the power of the bankruptcy. That's what holds your creditors back. So if you don't have a stay, it's worthless because they can go back to the Supreme Court and file for the sale.
And just for those people who are not familiar with bankruptcy, what Jjais is talking about by saying a stay is it means it keeps the creditors at bay. That is it the 341 creditors meeting you were referring to?
Right. So the 341 is the creditors meeting.
Right. So the 341, I'm sorry, I got the stay section confused with the creditor section. But the 341 creditors are all filing claims against your monies, against your filing. So you're going to have to, fill out a means test still Is that
Mhm.
correct? Before you file?
Yes, that's all
And
part
then-
of the filing. Yes.
Right, and then
Usually way
secondly,
too complicated for people to do on their own. It's the attorney that has to crunch the numbers and
yes,
make
it's
sure
the
that you
attorney,
qualify.
definitely, but you have
Mhm.
to definitely do a means test. But secondly, you also in your petition, your 7 or 13 or whatever, you're listing everybody you owe money to. So
Mhm.
all of those people get notices from the bankruptcy court that you are seeking the bankruptcy's protection. And with that, what happens is they have so many days within which to file a claim against you and your bankruptcy estate. It's called a bankruptcy estate,
Mhm.
just like
Yes.
there's a marital estate, or just like if you died, there would be an estate there. So essentially, they're going to file claims against that estate to try to get a piece of that money. And it's all automatic. So this is something that you should be aware of, and that's really not my question. I have a part 2 question, which is the reverse mortgage aspect. Thank you, Jjais, for that
Okay,
really
no
succinct,
problem.
very clear explanation. Regarding the foreclosure for the reverse mortgage, a reverse mortgage can be foreclosed upon in the instance where the mortgagor hasn't deceased, but has failed to pay taxes or water or insurance in order to protect the property. Is that correct, Ms. Davidson?
Yes, Miss Burden, that is very correct. Those 3
Okay.
items can cause a foreclosure to happen, yes.
Okay, so that triggers
And
a
failure to return what is called the shoops, sorry,
There's a
this one, just
form
forgive
that-
me. Every
there's
year
a
you have to
form that
send back and say you live in the
Yes.
property. It just, oh my gosh, I'm so sorry. I
But
do this every day and forget it.
it's a certification that the person
Yes.
hasn't died yet and that they're still residing in the property.
In the property,
That is done
yes.
annually. Is that
Occupancy
correct?
certificate, yes. It's called an occupancy certificate. Sorry, I just went
Mhm.
blank for a minute there.
Yeah,
Yes.
yeah, for sure.
And those those reverse mortgage foreclosures that are commenced because the borrower failed to pay the insurance and the taxes, those are the easiest ones actually to cure. Whether through bankruptcy, like Jjais could cure that 1, 2, 3, or NHS, we could get some money to just pay it off, because once you bring that taxes and insurance back up to date, they have to put you back on track with the reverse mortgage. So that's definitely a curable one. I know, Ms. Davidson, you had your hand up, but real quickly, can anyone address Mr. Alley's or Ms. Alley's question? What is a reinstatement of your loan? What is a reinstatement?
I could state that because it happens with the bank. It can happen with a bankruptcy. It can happen outside of a bankruptcy, but a reinstatement is where you look at the arrears. So all of the payments that you missed, right? And you ask your bank for a reinstatement letter, and they'll tell you if good until, let's say you asked for one today, you could get a reinstatement letter good until December 30th, right? And what they say is, this is the amount you need to pay us to put your loan back on track, and we need to get every penny of this by December 30th, right? Or 31st, or whatever I said. So they're giving you a timeline, and they're saying, this is the amount, all the payments you've missed, and if you pay this, it'll be like you never defaulted, right? And we'll put you back on track, and then you'll start paying your loan again as you should. And they're not required oftentimes in your loan paperwork once they accelerate to reinstate, but they do. Mhm.
Yeah, most residential, not those commercial investor loans,
not
but
the
most
commercial.
residential loans, you have a clause in there that says, even if I got behind, even if it's an hour before the sale, if I come up with all the money I owe you, they have to stop the foreclosure and put you back on track with your mortgage. It's a reinstatement clause, pretty much in most residential mortgages. Ms. Davidson?
Thank you so much, Ms. Dudley. And this is for Ms. Jjais.
Mhm.
Oftentimes we're working with clients who have filed bankruptcy.
Mhm.
And when we try to speak to the servicer, we're told that the debt has not been reaffirmed.
Mhm.
Can you talk on the which bankruptcy that happens, or if it's across all bankruptcies, and if so, how to address that?
So reaffirming a loan is not something we recommend you do in a bankruptcy. It somewhat defeats the purpose, but in all the years of filing bankruptcy, I've never had a client reaffirm. You can just continue to pay a loan as, so often that comes into play with certain car loans, because when you file bankruptcy, you want to keep your car note. You just keep paying it. I usually don't tell people to reaffirm it, because what happens is if you fall behind at some point, you still can use the benefit of the bankruptcy to deal with it. But if you reaffirm, you're sort of saying to them, and the judge usually has to approve these things, and they often don't. So some of these loans are bad. People were behind, they have bad credit, and they got kind of tough loans, but they're afraid that if they get rid of the car, try to buy another one, they won't get one. So you try to hold on to it. You don't typically reaffirm. I've never heard of reaffirming where the mortgage is concerned, because usually I'm fighting a foreclosure or there's an issue with the foreclosure. What happens is they say that they need authorization, and they're going to talk to your attorney. That's what they want. They want to talk to your attorney. They want the attorneys to talk in bankruptcy. However, the borrower should always be able to speak directly to the lender, because that's, sort of the two parties. If you think about it in Supreme Court, right? The lawyers talk, but the parties can talk. There's nothing that stops the parties from talking. It's just that a lawyer can't talk to a party without the other lawyer's permission, if you will. So when you file bankruptcy, sometimes you get pushback from the person you call, and they'll say, there's a bankruptcy marking, we can't talk to you, call the attorney or something like that. That's usually where you get a little runaround or a little blockage, but it should be the attorneys talking to the other attorneys, because they will enter the bankruptcy with an attorney. The creditor will come into the bankruptcy with an attorney, and you'll speak to that attorney. Sometimes the attorneys, where we're doing requests for mortgage assistance, sometimes the attorneys will say, go ahead and send the request for mortgage assistance package directly to the lender, just to, cut out the delay. But I always send a copy to the attorney too, because at the end of the day, we have to go into court, and at least my sending it to the attorney keeps their client honest about when they received it, right? Because the attorney can say, yes, I received a copy.
And that's important because, even though you are dealing with professionals, at the end of the day, as I mentioned, these are sharks, right? So God forbid, you're already in a bad situation. You don't want to ever go to them and need a favor, or you never want to go to them and try to start backpedaling and all of that and say, oh, but I did send it. And, and this is when I sent it. I don't have proof, but blah, 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 blah. You want that proof. You want that documentation for sure. And just to piggyback on to what Attorney Forde said, with a reaffirmation of a debt, what you're really doing is you're basically saying, although I filed for bankruptcy protection and I'm entitled to, some grace here, and I can work this out with you, I'm willing to forego that. And for you, I'm willing to take that debt on again. Now, in a bankruptcy setting, that can be seen as a preference or a preferential transfer. Would you agree, Jjais?
Yes, that's why a judge might not approve it. It's
right. So
because there's a hierarchy of creditors, and you have to follow that hierarchy.
Absolutely. And you can't give money to one and say, you know what, I owe this array of people, and I want to keep, like, say it is your mortgage. I want to keep my house, but I don't want to pay for my car. And if you file in bankruptcy, they'll undo those transfers. Typically, at least when I was practicing bankruptcy, within 90 days of the filing. So they go back 90 days, and all of those transfers or payments that you made in order to keep good relationships and preferential relationships with those particular people you want to deal with, and you want to protect your good name, that's out. all those people, they're called pari passu. Everybody's on the same playing level, and it's called being pari passu. That means you're here and here. That's it. And everybody gets paid the same. If everybody's taking a penny on the dollar, everybody's taking a penny on the dollar. With respect to that house, however, that's something called a secured debt. And the debt that is owed is secured and guaranteed by the house that it's filed against. And Jjais, if you wanted to, you could explain what that is.
Yeah, secured creditors are the strongest creditors, right? And then there's even priority amongst them. But what I wanted to say about, preferential payments, essentially fraudulent transfers and so forth. I get people who think, I really want to keep that Amex. I don't want to let them. So sometimes they won't tell me about something. But what someone mentioned, sharks in the water and all this, bankruptcy is public. Now, your neighbor is not going and looking up whether you filed bankruptcy, but bankruptcy is a public filing, and you do have people that comb through and look, and that's their job, to send certain advertisements out to people for various reasons that I won't get into here. But there's a lot going on when you file. A lot of people that come knocking on your door because they've seen that you file, and they know people tend to prey on people that are in a desperate situation, right? And so, but my point being, it's public. It goes on your credit report. You're gonna go try to use that Amex, and it's gonna be shut down anyway. So you're not gonna be able, when you file bankruptcy, you're not gonna be able to hold on to any of your credit cards. They're all going to get locked down. Because think about it. You're saying, I can't pay my debts. I need to either restructure or liquidate. Why is anyone going to let you run up any more of a tab? So you've got to be prepared to let all that go. But I think it was Miss Malloy who said, but at the end of this is a fresh start. You're like a phoenix rising. Okay. So there's a start over, and people would be very surprised at how quickly you can rebuild once you stop the bleeding. Right? You basically cauterize and move forward, as opposed to just putting a tight tourniquet that loosens every so often and the bleeding just keeps continuing and you're not really healing.
But I think at the end of the day, the reality here is, as soon as you know you're in trouble, and that is, when you're in trouble, when you can't meet those payments, when it's taking you now 3 months to make the payment that you should have made 3 months ago. That. So don't let it get to the point where you have to file bankruptcy. And the thing is that you can do, if you're going to do a modification anyway, if that's all you're being offered in the bankruptcy court anyway, why do you want to alert Amex or Citibank or Bank of America, who holds your credit card, or your car note? Why do you want to alert all your creditors like it's going to be on French Street that you are financially struggling? You don't want that. You really want, if you're going to work with the bank anyway and be forced to, do it early, get it done, and then save yourself the trouble.
I am definitely the court of last resort.
Yes.
All right, I want to again thank everyone. I want to thank all our presenters, Angella Davidson, Crystal Burden, Jjais Forde, Janay Malloy, and Lori Miller. I would like to, the Du Bois Bunch Center legal arm would like to thank our co-sponsors for this program. Again, to all the registrants, we are having a foreclosure clinic where you are able to sit down one-on-one with an attorney to discuss your specific case. And overall, the whole point is, again, like Ms. Burden said, when you're about to fall, not when you have fallen, when you're about to fall behind on your mortgage. That's when you should make your first point in contact with probably with one of these agencies, NHS or the Du Bois Bunch Center. And then you have until a second up until that foreclosure auction is actually held to do something. So 1 minute before, you can call Jjais and she can file that bankruptcy. I've seen her do it. And you can call Janay Malloy, who can have a closing 1 minute before an auction and quickly get a payoff to a bank. So you own the house through that point. I would like to thank all the attendees. I would like to thank all the members of the Du Bois Bunch Center, and specifically Dr. Blair and the co-moderator, Dr. Frank Hurley. Again, you are on our mailing list. We'll be in contact with you for any follow-up foreclosure clinic. Any last words, Dr. Hurley? Or Latoya Benjamin? Dr.
No, I just gotta say, 40 years of practice, I really enjoyed this. I listened to everyone. I learned a lot. I took notes. So, I'm always a student. I had a lot to say, but it's always good to listen. So thank you for the opportunity, and thank you all, the presenters. You all were wonderful. You gave your time, and you really gave a lot of information. So thank you all.
Thank you.
Thank you.
Hey, everyone.
Pleasure.
Have a wonderful night.
Thanks,
Thank you
everyone.
so
Good
much.
night. Thank you.
Really enjoyed it.
Yeah, me
Thank
too,
you.
everybody. Have a good night.
Good
Thank
night.
you.
Bye.